Welcome to J is for Justice podcast. If live breaking news and following true crime is your thing, then please consider subscribing to my channel. And if you like what you see in my videos, please consider giving them a thumbs up. Never a dull moment. And how is that? Is that better? My guest says yes. He's nodding his head backstage. So we were playing a violin for all of the criminals that we're going to talk about today. That was the little violin that we play. So just consider it's a chipmunk playing the violin. Oh my gosh. Welcome, you guys. Happy Monday. I was just telling you guys, happy Monday. We're going to be talking to our good friend Dmitriy. And we're going to be talking about some of these cases and the craziness that's going on and get a lawyer's perspective so that we know where it stands without any rumors and hearsay, gossip that, you know, all these people want to talk about. And then we also can kind of know what to expect next. So I hope you guys liked the little violin. Without further ado, I'm going to add Dmitriy up here. What's up, Dmitriy?
Doing well. How are you?
I'm better now, I guess, that everybody can hear me and I don't sound like a little screeching chipmunk.
That sounded strange there for a minute. That's okay.
Hey, at least I fixed it, right?
Absolutely.
Mm-hmm. Oh my goodness, too funny, too funny. Well, thanks for joining us on this Monday. Hope you're having a good Monday up there in New York.
Pretty good. Can't complain. Can't complain.
Is it getting chilly?
It's getting chilly. It's getting chilly.
It feels like fall.
Couple more weeks and I think it'll be a done deal for the
man. Okay. Nearing the end. The end.
Pros and cons, you know.
Very true. Well, I'm here in Florida and we had this cold front come through and I tell myself this is why I live here. It's a high of 69 today.
Wow.
You can't beat it, you know. It's wonderful.
Look at you. Very nice. Mm-hmm. I go to Florida a lot. I love Florida.
Yeah, it's great. It's great. It's getting a little crazy. It's getting a little overcrowded, but
yeah,
you can't beat the weather, you know, you can't, especially the winters here.
That's right. That's right. Everybody's going down there, you know?
Yep, they sure are. They sure are in droves.
Yeah.
So those of you that are new here and maybe don't know who Dmitriy is, Dmitriy, do you want to give us a little brief rundown of you and what your channel is and what you got going on?
Absolutely. So I'm a lawyer in New York. I'm also a professor and I teach law-related classes. I practice in criminal law and family law and a bunch of other things that tend to get messy and dirty sometimes, but that's okay. And in addition to that, I have a YouTube channel where I talk about the law and interview folks on the law. And if people want to check that out, I started for my students. It's not for money or anything, but if anybody wants to check it out and subscribe, that'd be great. It's youtube.com @DShackLaw. You know, you'll see it right there on my little tagline or whatever it's called.
Yes, it's in the description.
DShackLaw. So feel free, folks.
Thank you, Miss Robin, for throwing the link up in the chat so quick.
Oh,
they're on it today. They are on it.
Yeah, very good, very good. I'm on it as well. So let's get going, folks.
All right, let's get going. So our first thing right here is Miss Carlee Russell. If you didn't follow Carlee Russell, she was an Alabama nursing student, Carletha, Carlee Russell, and she faked her own kidnapping there in Hoover, Alabama. She called 911 to report a toddler missing on the highway. But she was in court last week and she pled not guilty. But she was found guilty of false kidnapping and ordered to pay about $18,000 in restitution and spend a year in jail. So, Dmitry, what are your thoughts on this? Because I know we talked about this. This is our first thing we ever talked about.
Yeah, she was found guilty. What a shock. Who saw
Right?
that coming? Well, I mean, her own lawyer held a press conference and admitted that she did it. So I don't know. Look, this case is really weird because you have these two kind of countervailing interests, right? Because obviously, we as society have an interest in people not reporting fake crimes, not making up crimes, not using government resources and the police to further whatever objective they may have that isn't for the purpose of truthfully reporting a crime. And that's important, right? Because if the government, and by the government, I mean police and all other law enforcement agencies, aren't investigating real crime, then that's a problem because they're investigating made up crime, right?
Mm-hmm.
On the other hand, when you have a case like this, it's easy to come to the conclusion that we're all coming to. It's easy for the judge to come to the conclusion that the judge had come to in this case, right? The problem with something like this is the collateral damage, right? Because you have a case like this, and what you don't want is for the next victim of a crime to be afraid that if he or she may not have all their T's crossed and I's dotted, that at some point it may look like a crime is made up and there may be consequences. Now, look, as somebody who does this for a living, I can tell you that there's a whole lot of gray in the criminal law. People almost never completely make stuff up out of the blue like she did here. That almost never happens. Sometimes, but almost never.
Mm-hmm.
And so it's not something we really have to worry about. But it does create that possible issue, right? We don't want victims of crimes to hesitate at all in reporting crimes, at all, right? We want them to go to the police and say what they feel and then let the police do their work. So it's I guess, justice served that she was convicted. I get that, not disputing that, but we have to be careful before we use this as a vehicle to condemn how the criminal justice system works, you know?
Right. I mean, some people think she got off lightly. Some people think she should have gotten, more of a sentence. But how does this work? Because she left court, like she didn't go directly to jail. She left. And then now she's appealing this conviction, this ruling. So what happens from that point, Dmitry?
So the way these things work is oftentimes upon a conviction, the judge can either remand the defendant right away, which means send the defendant away to the term of incarceration, or the judge can defer the sentencing, right? Set a sentencing date. In federal court, for example, that's almost always what happens, right? A judge will, obviously, there'll be a judgment of conviction, either by a jury or by a judge, and the sentencing date will be thereafter held maybe a couple of months, right? In state court, you have options. People sometimes go right away. Sometimes there are deferring sentencing dates. Now, in cases of appeal, things get a little tricky, right? Because when folks appeal convictions, you run the risk of incarcerating an innocent person, right? Because you have arguments technically that may have merit on appeal. And so what lawyers often do is they ask for the judge to stay the sentence pending the appeal. And then you have another problem where an appeal could last several months and many months, and you're kind of lingering with this case. So that's kind of the issue here, right? The judge will have to decide whether or not the sentence will be stayed pending appeal or whether he'll put her in pending appeal. And then if the case is, the verdict is reversed at some point, she'll obviously be released.
Okay. Well, thanks for explaining that because I was a little confused that she was leaving court, with being found guilty. So
Very common.
that's good to know. I mean, I'm glad that I don't know these things because it means
Yeah,
I've never experienced them.
exactly right. That's what I tell when I have clients come into my office and they say, "Oh, this is my first time. I don't even know what's happening," and I go,
Yeah,
"Oh, that's a good thing. That's not. You
right, exactly.
don't
Lu-
want to know what's happening."
Luna has a really good question.
Yeah,
She said, "We don't know what she was going through. Please, Jay, ask him whether her mental state was examinated and whether that means something."
that's a great question. That's a
Hmm.
terrific question. So look, in order for somebody to commit a crime legally, and what I mean by that is, in order for them to be convicted of a crime, the prosecutor has to prove mens rea, mental state, right? And that can be either intent or knowledge or recklessness or negligence, in different states phrase it in different ways. And you have to prove, generally speaking, in the criminal law, in order to convict somebody, that something was in their head, right? And you take that mental state and you combine it with what they call the actus reus, the physical act, right? To cause a certain event, right? Which is the result, that is the crime. So when that happens, one defense that a defense lawyer may explore is incapacity, right? Or some places call it insanity, right? And you explore whether or not that mental state element is satisfied. Okay. And that's what happened here. I presume that this was something explored by the defense lawyer and used as a defense if it could have been. Now, in order for insanity to be a defense, you have to meet very strict criteria, right? And there are different insanity tests depending where you are in the country. Generally, it has to do with something like the defendant lacked the capacity to understand the consequences of his or her actions, right? It can be that the person was upset or depressed or anxious and therefore committed a crime. That's not a defense, right? That may be a mitigating factor, as they call it, for sentencing, for example, but that's not a legal defense. And so that is the way mental health issues work when it comes to defending a criminal case.
I'm glad you mentioned depression and, along those terms of mental, illnesses or mental things that people
All,
can be suffering from. And it's
all
interesting to know
very,
that's not one of them. I mean,
all very real issues, right? That
right.
people go through. I mean, we're
But it
very,
doesn't fit
very.
under the law of insanity, right?
I don't want to say it doesn't fit. It may, depending on the state that you're in and the
The circumstances.
the circumstances, right? You don't want to say that, because depression is a loud word that means so many different things, and
Mhm.
it really, you should
And you don't want
defer
to downplay anybody's, mental health conditions.
and you also don't want to put yourself in the shoes of a clinician who really can connect these dots the right way. So what you can do in court is come in and say, my client was upset about something and therefore committed a crime. That's not a defense, right?
Mhm.
That's what I mean, because I think there was some discussion in this case about why she may have done this. This is all from the press. None of this is verified
Yeah.
as far as I knew. And if those issues were in fact accurate, which again nobody knows anything, then it's not necessarily true that that could have worked in her favor here.
Mhm. Mhm. And I agree with Selena, who says, "I believe her intention was attention." I don't know why, but obviously maybe a boyfriend or something like that. But Kendi has an interesting question. Would there be a tox screen? When she came home that morning and they called 911 and said she's home, she's breathing, and she went to the hospital, is that something she would have to have consented to? Or could they have done that without her consent?
It depends. It's a weird question. A tox screen?
Like
Um,
a drug test.
when you say consent, right? What do you mean by that? In
Like when
order,
she was taken to the hospital, did they say, "Okay, we wanna draw blood to see if you have anything, any drugs or anything in your system. If you say you were abducted, I mean, we want to see if this person drugged you.
Yeah. If there was some indication that the police, the government, wanted to get her to get a tox screen, to then use that tox screen in a criminal case against her, you have a whole set of constitutional rules about consent and Fourth Amendment and searches and seizures, right? What the government can pull out of your body to use against you in court, right? There are whole constitutional doctrines about whether or not those things are in effect confessions and things of that nature. So that gets real delicate. If she consented, that makes the analysis a bit easier, but it's still a complex analysis. Now, that's different than if she's suffering and the doctor in a hospital had to do something for medical reasons. That's a different story. But if you're going to pull something out of her body to use against her in a criminal case, that's a different. There's a whole body of Supreme Court case law and the courts that are under the circuits, right, that are instructive as to this. It's a real complex issue. As you can imagine, it would be, right?
Yeah, I mean, you have a girl who says that she was abducted and possibly harmed, and then you're talking about wanting to do a blood screen on her. It's
right.
Slippery slope there.
There was a famous Supreme Court case where there was, well, I'm going to just simplify it, right? There was a boy that was accused of dealing in drugs. And when the police came to his house to search, he swallowed them all. And they wanted to say, okay, we're going to go to the hospital and pull him out of you. And he said, no, you can't do that. And they did. And he was convicted. It went to the Supreme Court, so on and so forth.
Wow.
So there's a whole body of case law about what the police can take out of your body to use against you in a criminal case. And thank God for that. No.
Did they use the reason that he could have died from having ingested all the drugs? Is that why they were able to?
But that's different, right? So if they take it out of his body for a purpose not to use against him in court, then there are legal exceptions to the Fourth Amendment, let's say, that allow it to possibly come in. And as a general matter, by the way, judges very rarely exclude evidence, right? The exclusionary rule, which is a big deal in criminal law and constitutional law, the fruits of the poisonous tree doctrine, which is a big deal in criminal law and constitutional law. Those are very rarely relied upon to exclude evidence, to suppress evidence, as they say in criminal cases.
John Gahn says, give her 6 months in prison and let's move on.
Well, yeah, maybe. We will see. Right?
What do you think she'll end up? I mean, if they said she can face up to a year, do you think that she'll do that time?
It depends on the sentencing rules in Alabama. I'm a lawyer in New York. Typically, they have some time that you must serve prior to being eligible for some early release in most of these places.
Seems like it, yeah. I mean, especially for misdemeanors, right?
Right.
Hi, Potato. She's listening on her way home. Hello, Miss Potato. All right, are we ready to put Carlee Russell aside for now and call it a day on Carlee Russell? I say we do. Let's move on to the next. The next topic is going to be Bryan Kohberger. We love talking about Bryan Kohberger, but all right. So I sent you some information on this one, I believe.
Yep.
This author here, he's an author, reporter. He's been around for ages. This guy has been around for ages. He's got a Pulitzer Prize, all this stuff, right? He's an award-winning author. And he's writing a piece on this crime, and he's talking to anybody and everybody. Well, it's recently come out that he got information that there was a leak from a grand juror in this case. And allegedly the leak was given to a grieving victim's, or a father of a victim, a grieving father was given this information, allegedly. When we talk about a grand jury, what's the likelihood that a grand juror is going to leak information to a grieving father. And you're like, have you ever seen something like this, I guess?
You hear about it. It happens almost never. You hear
Really?
about it. Yeah, I mean, look, I don't want to say it happens almost never. Jurors probably violate their oath more times than we'd like to discuss, right?
Really?
Because in every criminal case, right, the judge will issue instructions and say, you cannot talk to anybody about this case.
Mm-hmm.
If you're a juror sitting on a months-long murder case, what are the chances that won't happen? We all hope it doesn't. But chances are probably more likely than not. The question then becomes whether or not and to what extent do you punish a juror for doing that?
Yeah.
And that becomes dicey, right? Because we want people to serve on juries. We want people to want to serve on juries. We already have a system here in this country where nobody wants to serve on a jury and everybody tries to get out of it in every way they can. And so the last thing you want to do is, on top of all the other stuff, right, taking people away from their jobs and their families and so on and so forth, you want to essentially have them serve under threat, which is essentially the case, right? You do, because they have an oath and you can't violate that oath.
Mm-hmm.
And so do we punish jurors too much for that? I would imagine it depends on the motive. If somebody's doing it to help a grieving parent, that's one thing. If somebody's doing it to sell information or, for more perhaps sinister purposes, then that's a different story. So it probably happens, unfortunately, more often than we'd like to discuss.
So what can this mean for the future of the case? Because the defendant's already trying to get the grand jury indictment thrown out. Is this going to give him the grounds to get that thrown out?
Probably not.
You don't think so?
I don't think it'll get him the grounds to throw it out, absent more information. We'd have to know more about the grand jury. I don't think that if you take this one isolated occurrence, that's enough to dismiss an indictment. Because you'd have to dismiss it on certain grounds and have to show certain things. So I don't think it'd be enough. But it would depend on what else happened there, the degree to which that juror or maybe others had an influence that was improper on the jury, and so on and so forth. So that's a tough one on the moment.
Right. Like Mike Sanner just said, decision by the grand jury was made before the leak. Does that matter?
Well, but that's not the issue, right? The issue is that the lawyers will argue, I presume, is that if this juror was willing to do this, what else happened, right? If this juror is apt to not, adhere to that juror's oath, what else could that juror have done? And then you get into speculation and other things. From what you're telling me, it doesn't strike me as enough to get an indictment dismissed, but who knows?
Do you think that it could, like the defense could go deeper into investigating this person and possibly interview the grand juror?
They would have to make a showing. They would have to make a showing as to whether or not that's necessary. Right. You'd also have to presumably stop the case while this is all happening, because
that's my next question. Would the judge call everybody in and say, all right, we need to talk about this?
Again, that would depend, right? It would depend on how easily accessible the members of the grand jury are and how fast that process can get done, because there are a whole bunch of questions that come into play, including speedy trial, right? The defendant can't just sit around waiting for this trial to come to an end. There are constitutional rights there. So it can get real messy. But the first thing that has to happen is the defense has to show a real connection between a taint and this act. And whether or not and the degree to which they could do that is what will impact this decision.
Okay, so let me give you another scenario and imagine this being your client. Okay. You have this guy who's accused of these 4 murders, right? And then you have this dad who has hit between him and his daughter, which is in the middle. Those two in the beginning felt like police were not giving them enough info. So they took it upon themselves to do their own investigating. I don't know if you've ever seen a family do this in a case, but we've seen it and we've seen it hard. So now we've found out, allegedly, he denies all of this, but he went door to door in the neighborhood to try to find information There was audio leaked early on from a Ring doorbell of a neighbor. We just have him, digging into things online, getting tips from prisoners that ended up being false. All these fake videos coming into him showing a white Elantra. Turns out he had it analyzed. It was a false video. So we've got internet people sending this father, just tons of information, and he's deciphering through it, and they're trying to figure it out on their own because the police were so tight-lipped. So now with this grand juror leak on top of everything else, do you think that that could hinder the case at all at this point?
No.
No.
No, look, parents, anybody can do whatever they want to look into any case they want, as long as they don't break the law, right? Obviously, once you start messing around with jurors and things like that, that's a big deal. Once you
Mhm.
start finagling with the evidence, once you start impacting prosecutors and the administration of justice, as they say, that's a different story. You now cross the line, and now you can suffer real penalties. But anybody can do whatever they want to investigate a criminal case. That's the short answer. Just don't break the law when you do it.
Okay, so that brings me to my next happening in this case. So allegedly they have a secret witness, an informant that they've kept under wraps, and the dad found out who it was, and he set up a meeting with this person, and he was about to meet with them. Now this is where I want to get your opinion, because it's been said that the dad's lawyer received a letter from the FBI saying quit meddling with the witnesses. Does that sound like something the FBI would do, send a letter to his lawyer?
No, but
No.
the content of the letter isn't wrong, right? That's witness tampering, and you can get in a whole lot of trouble for witness tampering. I presume the person, the dad here, wasn't just doing this for investigatory purposes. He was probably trying to get information or do something.
He
You got
wants to know why.
Yeah,
He
yeah,
wants to know why this happened.
yeah. You got to be real careful when you do that. You got to be real careful in any criminal case, right? One thing that I tell my clients always is don't mess with the witnesses. Don't go and talk to them. Don't meet with them. Don't text them. Don't reach out and try to see what they're going to say or who they said what to. Because you don't want more charges. You don't want more stuff, right? The last thing this
Right.
dad wants is, on top of all the other god awful things that he's going through, to add this, right?
Yeah.
And so in terms of the FBI, this is a state case, not a federal case. I don't know about that. Although I suppose anything is possible. I mean, perhaps there are some interstate issues. I don't know. It's possible the FBI would get involved. But
I just wondered if a letter would be their means of communication about something like that.
not really. FBI typically makes itself known in other ways. But the content is certainly true, and this guy should get a lawyer and stop doing all these things.
Yeah. Yeah. Well, they did further the gag order at one point. So they had they had the dissemination order. Then they expanded it to the lawyers of the victims' families. So I think that, a lot of this they knew was going on, and they were trying to shut him down, and then he was getting more frustrated. So it was kind of like a push pull type of thing. I just wondered if this could have any effect on the case. I mean, if he didn't meet with the confidential informant, then he's okay. He didn't do anything wrong. I
Well,
mean, he's pushing it,
but
right?
he did reach out. He did try to make contact, right?
Yeah, but he had to have found out who he was somehow. That's the thing. Someone must be leaking.
That's a different story. Maybe there are other people that are responsible for this stuff here that have their own issues.
What do they do with that in a high profile case like this? Do they just kind of ignore the stuff that really, I mean,
Well, when you say what do they do, who does to whom? Depending.
the court, like how does the court handle leaks and stuff like that?
If there is a leak of information that otherwise could not be responsible to anybody other than the people involved in the case, right? Because there's certain confidential information, sensitive information that only lawyers are privy to. Sometimes not even defense lawyers. Sometimes it's just prosecutors. What the judge would typically do at first glance is get on the record and be very stern and say, guys, I don't know what's happening. Something is coming out of somewhere, I think. You all know what you have to do, what you can do, what you can't do. Don't make me make this inquiry a deeper inquiry. And if this happens again, then it becomes a lot more detailed.
Would that be done behind the scenes?
Well, it can be, but a judge would typically put that on the record so nobody could say that we didn't know or we didn't,
You didn't address it.
Yeah. And if there is somebody in question, if they know or presume or suspect who may have done it, then the judge may take a closer look at that person and it becomes a bit more detailed. So that's how the judge would generally deal with it.
Got you. Okay, so that kind of explains. I just didn't know what would happen next. If this was true that the grand juror leaked something, would we for sure see the judge pull everybody into the courtroom to kind of sort through it, or maybe not?
Not for sure. But
not necessarily.
It's a possibility. It's tough to do in these kinds of cases, right?
Yeah.
Because you want the case to move.
Right. Yeah, absolutely. Thank you for clarifying that. I know this stuff gets so confusing for us. And there's a lot going on at once. So the final thing, and I just want to say right here, I want to just preface or not preface, but wrap that up by saying I feel for Steve, the dad in this case. I can't imagine the hell he's going through, not knowing why these horrible things happened to his daughter and her friends. And I in no way blame him for his behavior. I can't judge him. So our next one is Delphi. This just came out. This just happened. So this one here, crazy case. This has been going on since 2017. They just made an arrest a year ago. This is the murders of Abby and Libby in Delphi, Indiana. And what currently just happened is another leak. So today's, like I said, Dmitry, today's topic is leaks.
Sure.
So what happened in this one is crime scene photos this time. We've had several leaks throughout the years in this case. We've had witness lists leaked. We've had other documents leaked. It's been a mess. But we have a trial that's supposed to start in January. And now we have crime scene photos that were leaked by a prior member of the defense team, passed on to another individual that was then passed on to YouTubers. And then a podcaster contacted the police and the court and let them know that they had these photos. So when this came out last week, the judge promptly set a hearing for this week and told the lawyers, clear your schedules. We're going to do a status conference and we're going to address some of these recent happenings. Okay. So in the meantime, we've got a trial that's supposed to start. Then we've got 3 days later, after this hearing is scheduled, we have the person who used to work for the defense that allegedly leaked these photos unalived himself. So this all transpired in the last week. We don't know if it's associated, if it's because of this or not. He has a wife and children. Our thoughts go out to him, to his family. It's horrible. It's a horrible situation to an already horrible crime. But what can happen, Dmitry, with crime scene photos? They've had this all under wraps for years, 7 years. And now this huge leak of they came out with the Odinism defense. And now these photos of the bodies have been leaked that apparently back up their narrative. Where do we stand?
Well, when a leak is in question, the real important part becomes who leaked it. Because the folks involved in this case, all depending on who they are, have different duties, right? As to what they can do, what they cannot do. And that will depend on the judge's actions, right? Private citizens can generally speaking, do whatever they want when it comes to disclosing information. Generally speaking, I don't want, you can get sued for defamation if you lie and other things, and I get that, and other things possibly. But generally can do whatever you want. Once you're involved in the criminal process, once you're a cop or a prosecutor, a defense lawyer, work for the courts, juror, once you do that and then you leak, you not only have your potential criminal issues, you have professional issues, right? Because all of these people take duties and take oaths and sign their names to all these things that basically say that they will abide by the rules of the court. And so what can happen to whoever leaked what will depend on who was the leaker.
Mm-hmm.
That's the most important question here. That's what will have to be addressed really before any further analysis takes
So
place.
it wouldn't necessarily fall on the defense lawyers if they have to prove that the defense lawyers gave it to this guy for a sinister reason to share it, right?
The defense lawyers leaked information that they weren't supposed to leak for whatever reason, and then somebody shares it, then the defense lawyers can get in trouble for sure.
So if someone from their team shares something, are they responsible for that person? Are they held to the standard of you're responsible for, the information shared within your team and that being held confidential?
So in terms of liability, those kinds of things exist, but not in terms of being sanctioned by the court. Generally speaking, if the lawyers didn't know that somebody working for them did certain things, they won't be held responsible unless there's some connection that's drawn.
Mm-hmm. They have to be able to prove that they knew it was happening.
Yeah, they have to show some degree of culpability. Either they knew it was happening or they overlooked something and therefore it happened. Things like that.
Can the judge remove them from this case without proving that?
The judge can do whatever the judge wants, right? When it comes to a criminal case, every defendant has the right to counsel. If you're going to deprive a defendant of the lawyer that defendant wants, you better have a real good reason for doing it, right? If there's a conflict of interests, that may be one reason. The judge can also do things like create such an environment for that lawyer that the lawyer may want to get off himself, and that may be problematic to do in the middle of a case. So those are kind of the moving parts in question now.
It just seems crazy to me to think about those lawyers being a part of any kind of leak and then continuing forward with the case. It seems very
they could be punished. They could be referred to the disciplinary committee. Their licenses may be in jeopardy. But
there's a whole lot of avenues it could go.
A whole lot of avenues. But you got to be real careful before you take that lawyer away from his client. Right? Because now you're interfering with the attorney-client relationship and you're interfering with the right to counsel. And
oh man.
Yes, we don't like that. Right? We like people to be able to choose and keep their lawyers.
Ooh, see that gets sticky when you have the rights of the defendant versus everything that's going on, right?
Well, right. Well, again, when it comes to a criminal case, all that matters is the rights of the defendant. Right? The whole reason we have all these rules is so that the government, the all-powerful, almighty, all-resourceful government, can't do what it wants to the defendant. Right? So you always have to think of these questions in the context of the impact on the defendant. The defendant is why the Constitution exists, to protect the defendant. Right? That's why we were founded, right?
Right. And we tend to we hate the defendant because he did this or that,
You can hate him, but you still got to protect his rights.
You still got to protect his rights, yeah.
The right to a lawyer and the lawyer you want, that's a pretty big one.
Right, especially if he says, no, I really don't want to switch lawyers, right?
That's right.
And that creates even a stronger case to keep those lawyers in place for him.
Absolutely right. Absolutely right. You're going to have a real good argument. For example, conflict of interest is one, right? That's one reason that lawyers are sometimes removed from cases, right? If, for example, you have a criminal case where it turns out that the defendant's lawyer at some point represented a witness in the case. If that's the case, now that lawyer is in conflict, and now you may have to remove that that lawyer, right? Or you may have to create a mechanism by which another lawyer does a certain witness, and then that lawyer stays on for the other portions of the case. Right. So those are the ways that judges deal with these issues.
It's funny to me, listening to you talk as a lawyer, that none of this surprised you. Like, you weren't like, "Oh my god, I can't believe this happened." Like, none of it really seems shocking to you
It's
because
not
my
shocking.
I'm
Yeah, go
looking
ahead.
at my questions and I'm just like, "What can happen? Like, what's next?" I'm thinking this is such a big deal.
Look, don't get me wrong. Lawyers doing bad things in cases is a really big deal for the lawyers. I mean,
Sure.
you're risking your license, you're risking other things. I mean, it's a really, when you're a lawyer, you really don't want to ever cross that line because that's a real bad place to be. Um,
Yeah. So it
but
says something about integrity,
it's
right?
not about integrity. The rules say you can't do certain things. Listen, the profession is structured such that we don't rely on the integrity of lawyers. you know,
That's true.
we
Good
regulate
point.
we
Good point.
regulate them. Obviously, lawyers have to maintain a certain degree of integrity because it is a self-regulating profession to a degree. But there are rules in place that lawyers can't violate, and practicing law is a privilege, not a right. And if you're, in violation of those rules, that privilege will be taken away from you at some point.
So that brings me to my next question on this. What, if anything, do these antics say about tell us about the defense's case? And does it tell us anything?
Well, look, you have to the extent that a lawyer is being zealous and is representing his or her client strongly, that's a good thing for the defense. You don't want lawyers to take that too far and violate any rules. And that doesn't, lawyers are required to explore every possible piece of information that may help their client. So that doesn't necessarily mean that they're struggling or their case is weak. Um,
Mhm.
you know, these are all conclusions that you can't really jump to yet.
So interesting to me. I love the whole defense
Hmm.
lawyer like way of thinking. So it brings me to another question that kind of piggybacks off that one. It doesn't necessarily mean they have a weak case at all, is what you're saying.
Not necessarily, right?
But as a defense lawyer, and this is kind of a more of a general question, not really case specific, I'm going to pick your brain a little bit on how you do things. Do you guys go back through discovery? So, like, let's say you're handling a murder and you go and you look through discovery. Do you see everybody that the, the police interviewed early on, and you read through all of those interviews, and if there's something maybe that piques your interest that you could possibly use to cast some doubt, that's you're gonna grab that, maybe, right? Like,
Of course.
so, like, if
Yes.
you okay, so for example, if you have a interview with people that are in Odinism, they are practicing Odinists, and then you have them speak, the prosecutor talking to a Purdue professor who, studied German runes and all this stuff. And he says, yeah, it does look like something that could be part of that. And that could be something that was staged to look like a certain group did that. But what my point is that they obviously prosecution didn't go forward with that narrative. They didn't move forward with this Odinism narrative for whatever reason. So, is that something as a defense lawyer that maybe, they didn't grasp onto that, but we have a Purdue professor saying it damn well could be, so that might be something that would entice you as far as a defense?
Most criminal cases are tried by defense lawyers on reasonable doubt. Okay. What that means is that you can go into to a case in one of two ways. Either you can try it on actual innocence, which is when you get up in front of the jury and you say, ladies and gentlemen of the jury, we will argue as the defense that our client is innocent of this, right? Because of X, Y, and Z. Or you get up in front of the jury and say, ladies and gentlemen of the jury, the prosecution has a burden of proof in this case. That burden is beyond a reasonable doubt. I, as the defense lawyer, my client, we have to do nothing here. We can sit and sleep. All right. And that does not remove the burden from the prosecution. So we will show you why the prosecution didn't meet that burden. That's called reasonable doubt. And what happens if you try a case on reasonable doubt? It should happen if you try a case on either of those. But if you try it particularly on reasonable doubt, then your goal in the case is to poke holes, right? Obviously, do it in good faith. obviously do it ethically. Don't, make arguments that are nonsensical and make stuff up and make frivolous points. You can get in trouble for that. You shouldn't do that. But your goal, your obligation as the defense lawyer is to do everything you can to make sure that you create enough in the case to have your client acquitted. Right. And so that may be part of it. You will go through every piece of paper and try to connect what you see in there to your defense. And if you're trying it on reasonable doubt, that's exactly what would happen. Right. So that's what you would do. And again, you should only do it in good faith, but that's what you would do.
When you say good faith, does that mean, as far as you're concerned, keeping it in the courtroom? How do you feel about theories and things being leaked before there's been a jury chosen? Like leaking things to the press and things like that.
Yeah.
Is that kind of skeezy antics there?
Well, yes, A. B, there are rules in place. And those rules are really specific, so you can't really rely on them too much. But there are rules in place, ethics rules, that will limit what you can say to the press, right? Lawyers can't talk to the press in order to impact the litigation. That's not allowed. Now, that rule is very hard to enforce. It almost is never enforced, right? Sometimes you have it in cases where lawyers will represent a client and write a book, things like that. But it's generally not enforced when lawyers talk to the press, because there are exceptions, and if you have a high profile case and you need to talk to the press to rebut allegations that have been reported on, you can do that. And then there are a bunch of other things. So you got to be careful. But generally, there aren't problems with lawyers talking to the press. You just have to make sure that you don't violate any rules, obviously.
Interesting. It's crazy to me what you guys, like, the little tactics you can use to kind of cast doubt, because really that's all they have to do. And if they're doing that, then they're doing a good job, right?
Yeah, and it depends, right? There are some lawyers, it's tough to put a blanket statement over this, because there are some lawyers that say none of that matters, it's all bull, and a jury has to believe you and believe your client's innocent, or else you could do whatever you want and the jury won't acquit, right? Excuse me. There are other lawyers that say none of it matters. All they have to do is like your client. If they like your client, they're gonna acquit, and if they don't, they're gonna convict. You never know.
It just depends on who it is, right? If they're likable, you can kind of use that to your advantage too.
It depends on a million different things. But your specific question as to going through the discovery, absolutely. Look, as a defense lawyer, in every case, criminal or otherwise, you should go through every piece of discovery very closely.
Yeah.
You do anything. Sure, of course.
So then the judge also put an order saying that the prosecution had to share all of their discovery by November 1 with the defense. How does that work, Dmitry? Is there discovery dumps? Because it seems to me like after all this time, a year, the defense should have everything that the prosecution has.
It depends on the discovery rules in the particular state. Different states have different rules. Some states make prosecutors turn over literally everything in their file. Some states don't.
Crazy.
And then, depending on what the judge orders and depending on what the obligations are in the state, lawyers may fight in court as to what was turned over and what wasn't. Judges may then issue orders as to what specific things must be turned over. If that doesn't work, you can go even further and hold hearings. And beyond that, you can always have discovery come out later. And as long as it's not, intentionally withheld to suppress, then discovery can come in later as long as there's no prejudice, right? What sometimes happens in a trial is there's a defense lawyer will make an opening statement. And then after that, some discovery will come in and the defense lawyer will say, now I want a mistrial because I opened on information that's now I didn't know about. And now the jury has heard this from me and I'm going to sound like an idiot. And now my client's going to be hurt as a result. And so I want a mistrial. I want to do this all over. There are different ways to do it. It's a complex area. Generally speaking, prosecutors won't get in trouble unless it's obvious that they withheld something, which happens very rarely.
It's just crazy to me that you can sit there as a defense lawyer and not know everything they have and what you're working with.
Yeah, and that is the contention that some people have. That is the quarrel that some people have, let's say, with the way the criminal justice system works, right? We have an adversarial system of justice. We've determined that the best way to get to a good result in a trial is to have a defendant hire a lawyer, and that lawyer will do the work that the lawyer has to do to combat what the prosecutors are doing. But the prosecutors have unlimited resources, right? They can do whatever they want. They're the ones dictating the charges and the evidence. And so you get into real questions about, whether or not the criminal justice system works the right way.
When do you, as the defense attorney, keep your ace, in your pocket until trial time? And when do you kind of like in this case, things, it's been dragging on and on and on. So there's going to be things that come out in the press and things like that. When do you decide, I'm going to maybe talk about things that are going on in the case versus be quiet about it and keep my, whatever you call it, your.
Yep. Well, first what you have to do is you have to look at the rules, because sometimes the rules will tell you when you have to disclose certain evidence.
Right.
When they don't, then it's really up to you, right? And if you're a defense lawyer, the good thing about being a defense lawyer is that you have no burden, right? You don't have to prove anything. So again, depending on the rules in the state, some states make defense lawyers turn over certain pieces of evidence, and then they have to, obviously. So you operate under what the rules say, and then you rely on your strategy, right, and your best judgment.
How do you feel? I don't know if it's a personal question, but how do you feel about defendants knowing they're guilty, right? They did it, but you still find something to like give the jurors some doubt. How do you personally like compartmentalize that? Like, because I know a lot of people are like, God, I don't know how defense lawyers sleep at night. They know these people are guilty and they still, will find some kind of loophole to, give doubt to the jury. What do you have to say about that?
That's why people hate lawyers, right? Because they think that they operate on technicality.
So they need one.
Right. Yeah. They think that lawyers, particularly criminal lawyers, operate on technicalities, right? That subvert justice, right? So look, a couple of things. Number one, you're required as a lawyer to represent a client zealously, right? If obviously you can't perjure, you can't induce perjury, you can't submit fake evidence, right? All that is obvious, basically, should be anyway. So if that's the case, then you operate within certain limits, right? If I know something is not true or true, I can't get up in court and say the opposite. That's not allowed. So those are really the restrictions within which I operate as a lawyer. As to how do you represent people if you know they're guilty? Morally speaking, it depends on the case, right? And if somebody is guilty, it'll depend for me anyway as to why. It'll depend on the circumstances, right? You have to dive into these things. You have to get to know your client. You have to see what happened, right? It's very simple and lazy to say somebody's guilty of something and therefore they don't deserve a good defense. That's just not the way that I choose to approach my work. No lawyer should. Every lawyer should dive deep into their work and see why certain things happen, and do it in such a way where you can sleep at night. And that's what I try to do.
It's interesting how you I mean, I get it. It's what you do every day. It's the way you think. You think totally different than a layperson does when they're approaching, looking at a crime in a court case, a trial.
Yeah, I mean, look, if you have a client that comes into your office and tells you a story, and you feel like you can't represent that client, then you shouldn't. Because
have you ever done that? Have you ever been like, I can't do it?
I don't remember, to be honest. I see people so every day. I don't know. I can't even remember of anything recently, to be quite honest. But if that's the way you feel, then you shouldn't take on that case. But in my opinion, it's not good when lawyers don't take on cases because they don't agree with the client's opinion or position on something, right? The rules say
Yeah,
that a lawyer, in taking on a case, does not endorse the client's views, right? Because if that were the case, then the really bad people in the world, the Unabombers and all these other people, they would never get lawyers. And you need
true.
these people to get lawyers, because we can all agree that some people are really, really bad, but I promise there's a huge division in our society as to all people, right? There are some people that you would consider reprehensible that I wouldn't, and vice versa. And so
Yeah.
if you start parsing it out like that, it becomes really difficult. You need all people to have good lawyers.
Yeah, and I think that it's a given that for anybody, it would be hard to, look at evidence in a child case, to see children brutally um unalived, I guess I can say.
Sure. Look. There are lawyers that deal with real tough cases, and I've dealt with real tough cases, and those cases are, um, sometimes they take a piece out of you because you're a human being anyway. Um, but it's important to remember your role here. And if you don't want to take on the case, don't take it on. But don't take it on and do your client a disservice, because nobody wins from that.
Lead with Love says my lawyer will not represent snitches. If they want to turn state's evidence, they have to go somewhere else.
Okay. Well, again, if somebody wants to turn state's evidence, why are they doing that? Right? The assumption is, when you label somebody a snitch, right? Then what you're presuming is that somebody did something wrong, got caught, and is now willing to benefit themselves by throwing somebody else under the bus. That's what people say when they refer to the word snitches.
Mm-hmm.
I assure you, cooperation is not that black and white. I assure you that's not always how it happens. Sometimes, right? But every case is fact specific, and every defendant is different. And no matter what, snitch or otherwise, these are all human beings. And that's not to say that they haven't done bad things or even horrible things, or things that none of us would agree with. But blanket statements in general, generalizations are not good, right? They're not good. You should never take somebody and put them in a certain category and say, now you're bad because you're in that category. In life in general, right? And the law is no different.
Potato says I'd feel more pressure being the prosecution if someone's obviously guilty and you fail to try it beyond reasonable doubt. It's on you more than the defense.
It's always on the prosecution. The prosecution has the burden, right? The prosecution has the burden of putting somebody on trial successfully. The defense has no burden. So I completely understand that and don't disagree with it.
I'm trying to see if we have any other. Women are sacred. How does a lawyer not give certain discovery? They do it all the time. I see lawyers complaining all the time in these cases we follow that we didn't get this or we didn't get that, and then they want more time, to review it, and then it's always a stall. So,
well, the answer to that question is because certain discovery, depending on where you are, doesn't have to be turned over, right? In New York, for example, the rules have changed in the past several years, but there was a time when you would only have to turn over information that you will admit in your trial. And you can see where a lot of information would get lost. Then the Supreme Court came along and said, well, okay, that's not cool. So what we're going to do is we're going to make you turn over not just that, but we're going to make you turn over evidence that may be exculpatory, because you're not going to use that in your trial, right? But the defendant still should get it. And so we're going to give them that. And recently in New York, they changed the laws to say basically everything has to be turned over, right? There was a time in this country many, many, many years ago where discovery didn't exist at all. You would just, prosecutors wouldn't turn over anything, and defense lawyers would do what they had to do. And, and obviously these things are different because now you have social media and the internet, and it's very hard to hide information like you could in 1929, right?
Right.
But discovery is a very, very, very complex area of law. It doesn't just mean you get everything that is out there in the world at all.
And it's not the prosecution's job with the discovery that they enter to decipher it for the defense. Like in Brian Koberger's case in Idaho, we had, the defense kept filing these motions like, we need the defense to number all of the cell phone data. We need them to organize it for us. Like, that's not the prosecution's duty, is it?
No, but the prosecution also can't just throw a bunch of crap on a doorstep and say, here you go. Right?
It has to have some kind of order.
It becomes really a cost analysis, right? Mm-hmm. Because think about it, right? If the prosecution really wanted to, it could turn over the discovery, but do it in such a way that would make the defense, think about it. There are cases in the world that, to take a white collar case, that in which you have tens of thousands, hundreds of thousands of documents, right? Tax returns and bank statements and check copies. And I assure you, in those kinds of cases, prosecutors could make a real problem for defense lawyers by the way in which they produce discovery.
Oh, I bet.
So you have a real kind of back and forth. But of course, there is something in the law called work product. The discovery does not entitle you to strategy. It doesn't entitle you to preparation. It entitles you to information and documents, generally speaking. But obviously, prosecutors can't turn over these things in such a way that will just cause problems for the defense.
Do you, as a defense lawyer, have to turn over certain items of discovery that you receive that they don't have? So it goes both ways.
It goes both ways. Prosecutors have more of a burden, I would say. And they should. It's their case.
Right. They always have more of a burden, just generally speaking.
Right. But yes, the answer to your question is yes.
And Robin has a question about social media's involvement in a lot of cases. Do you feel that social media can be used to your advantage as a defense lawyer if it was like a high profile case or something like that?
Well, what do you mean by social media? If you have a witness in a case, then you should certainly scour their social media if you're going to do a good job to see whether or not there's information on there you can use. Beyond that, not really. I mean, going into a Facebook group and listening to 1,000 people talk about something they don't know anything about, that doesn't really help. But sure, if you're going to use ways, if you're going to find ways to challenge the credibility of witnesses, then, you should certainly do your work.
One more question. I know we've been running for about an hour, and I appreciate you giving me an hour of your time, Dmitry. Jenny says this is probably a stupid question, which was no stupid questions here. But do defense lawyers only take on cases they believe the person is innocent, or do they try to get them off regardless? And we kind of talked about that just a minute ago, but I wanted to let you address that one.
No, yeah, you don't take on a case where you don't only take on cases where you think the person is innocent. Because your job is to represent the person to the best of your ability, irrespective of that. Now, look, again, lawyers are people, and there are some lawyers that'll say, I'll only take on a case if X, Y, and Z criteria are met. Those lawyers typically don't exist because it's very rare to be like that, because you won't get work if you create structures for yourself where you're not going to take on a case because of certain reason. It's very hard to take on cases. But also, it's not about, as the question here says, just trying to get them off regardless. That's not really
it's not your job.
It's one way to phrase the job, but it's not really that. Your job is to make sure that the justice system is run fairly, right? So it's not about getting somebody off. Although that's a nice way of putting it.
I think you should put that on your business cards as a little tagline.
Yeah.
Getting people off one at a time.
I don't know if I want to put that. But okay.
Oh, shit. That was loaded. All right. Next question. We've got one more, and then I have one for you, and then I'll let you go.
All right.
The next one is, have you ever had a prosecutor admit that they found your client innocent? Has that ever happened to you?
Yeah. Yeah, client will sometimes say they won't really say it in those terms, but they will call up and say, "Look, we did some more investigation, and we don't think it's within the interest of justice to prosecute your client anymore. and so we're going to dismiss the case. That does happen very rarely, but it happens. Sure.
That must be music to the client's ears when that happens.
Oh yeah.
Party time. Party time.
That's great.
So my question for you, I know you've been following the Trump happenings.
Yeah.
And I just heard that the judge put a partial gag order on Mr. Trump to prevent him from talking about the team that's prosecuting him. What are your thoughts on this? This is getting crazy.
I think the order was about court staff. I could be wrong. I think it's about public.
Yeah, court staff. You're right. Yes.
Yeah. So that's different, right? That's very different. Gag orders are tough because we have the First Amendment here. And in order for a judge to subvert the First Amendment, there must be a real good reason. And generally speaking, safety is a good reason, right? So if you have, a normal, hardworking person that does work for the court system, that person shouldn't be subjected to ridicule or danger or safety concerns.
Like the clerk and people like that.
Like the clerk and the secretaries, and it's not right to put them, even the judge, although you can make some argument because the judge is kind of the head of the courtroom, but even then, I mean, these are people doing jobs, right? And they shouldn't be put in jeopardy. And so the First Amendment will generally allow you to limit it that way. Once you get broader and once you prevent Trump from talking about prosecutors or election interference or, things of that nature, now you're getting into murky territory, especially during an election year where he's running and then he needs to talk about some of these things, or at least he, may feel the need to talk about some of these things. You don't want to run afoul of the First Amendment. It's a big no-no.
Are you continuing to cover this on your YouTube?
Absolutely.
Okay. So you guys, they do, and they should hear about it because it's never happened before.
Yeah. And it's just getting started. I mean, these prosecutions haven't even started yet. The criminal trials, all four of them haven't even started yet. One of them may be televised. So we'll see. I
mean, this is part of our history. So, it's never, whether you're on the right or the left or on any side, I'm not on any side. I just want to know what's going on in our country, and we can learn from it. We can also learn.
And it's so funny, I'm not a political person at all. I mean, I have opinions about things, but I'm not really a political person. When you talk about this kind of stuff, I just do it about the law, and people gauge they think that they're going to kind of gauge what your political leanings are. And they wrote out mean stuff to me sometimes. And I'm like, hey, guys, I'm not,
It's really it's a tough line there. Cause I get it too. If I talk about something that's going on politically, they're like, well, you're a true crime. Well, these are crimes, everything, it all kind of intertwines, but I don't get into the politics of it. I don't care if people love or hate him. I still want to talk about what's going on. So I appreciate you answering that. Cause I know a lot of people will try to make the whole discussion political, and it's not.
Right. Exactly. I'm with you on that.
Well, thank you so much, Mr. Dmitriy. Subscribe to Dmitriy Dshak Law, and we've got the link going through chat, and I appreciate your time.
Thank you so much for having me.
Yes, absolutely. Thanks for all the wealth of knowledge. I'm going to have to go back and replay this so that I absorb it. But thank you so much. It's always a pleasure, and we'll talk soon.
Of course. Bye-bye.
Bye, Dmitry. All right, guys, that was a lot of information, but really, really good information. Thank you, Lead with Love. She donated $10 and said, good work today. Love it. I think that we had a lot of really good questions, and now we wait, until Thursday for Richard Allen to go to his hearing, and then we find out kind of what's going to happen there. And yes, we have a birthday in the house. Had to wait until the end, but the mod boss Shell is celebrating a very special birthday today. So I want to give Shell lots of love. I want to thank you, Shell, for everything that you do, everything that you've done for me, for this show, for everybody that you've touched. You're a wonderful human, and happy birthday.
Happy birthday to you. Happy birthday to you. Happy birthday, 'cause you're awesome. Happy birthday to you.
Oh, Shell. I hope you have the best day ever. I love ya. And everybody give Shell lots of birthday love in chat. Island Thrifts coming in hot with $9.99. Thank you so much. You guys are the best. Look at all the birthday wishes. This is the biggest birthday party ever. Shell, you've got 200 people at your birthday party. When's the last time that shiz happened, huh? Huh? Have a great day, hun. I love you guys. Thank you guys for listening. Thank you guys for being respectful and coming with your great comments and questions today. Just to give you a little rendition. I don't even know where I'm getting these words today. I'm like pulling them out of the dictionary and they don't make sense. But what I'm working on for you guys is I want to deep dive this Delphi stuff. And yeah, we're getting people off one at a time over here. And I'm putting together some videos for you. So make sure you're subscribed and hit that all little bell, the filled in notification, and let's dance it out. Thank you guys. I love our community, and I will see you guys in the next live stream. Now let's dance it out with Punani's favorite song.
I don't give a damn. I don't really care about you and your problems. I don't give a damn. You talk way too much. I have heard enough about you and your problems. I don't give a damn. I don't give a damn. Damn, damn. I don't give a damn. Damn, damn. I don't give a damn. Damn, damn. I don't give a damn. You wanna be with me. You wanna feel something real, but I'm feeling differently. You're making plans to get to friends, but don't wanna face the fact that I ain't got time for that.